So we are live on the YouTube as well, right?
Yes.
Okay, so we'll wait for 2 more minutes and then we'll start.
Yes.
ओके शायद अविनाश सर ज्वाइन कर चुके लाइव अपनी
He's there. I'm just waiting for 2 more persons to join in. We will start at 3:10.
श्योर श्योर
मैम स्क्रीन शेयरिंग का एक बार मुझे अलाउ करिए ना.
A screen sharing option, yes. Lavnish ji, please करिए ना screen sharing option सर के लिए. सर आपका स्क्रीन शेयरिंग का होगा, लाइव देखिएगा एक बार.
यस यस चेक किया मैंने, इट्स वर्किंग.
जी 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 जी. So I think I welcome everyone to the webinar. Swapnil sir and VK sir is going to host this entire thing. I am here just facilitating the things. So all over to Swapnil sir and VK sir.
Yes, thank you, madam. I am once again honored and equally pleased to conduct this webinar with Avinash sir. He is my favorite professional and guide and mentor in GST. And I welcome him on behalf of
Voice is missing, Swapnil sir. Swapnil sir,
Hello.
your voice is not audible.
Is it audible now?
Yes, yes, yes.
यस
I am once again very much pleased and honored to conduct a webinar with Avinash sir. And today's topic is about judgment by Honorable Karnataka High Court, which is about quashing of Rule 89, Sub-Rule 4 and Clause C. This rule is about restricting the value of exports to some percent of the equivalent value of exports if sold domestically. And this rule intended to restrict the amount of refund to be granted. So this rule is passed by the Honorable Karnataka High Court, and we are conducting this webinar to understand the judgment of the High Court and also the views of Avinash sir. So I request sir to start his analysis.
Swapnil sir, I suggest VK Bothra ji to mention some details about AIMTPA and the vision and mission also, so that people who have joined us is aware what is AIMTPA intending. And let's have a formal intro of the sir. I'm sure he doesn't need an intro, but for the sake of the information of the public, right? So Bothra sir, all over to you.
Thank you, ma'am. Thank you, Swapnil sir. Welcome, Avinash sir. MTP जो ये पुराना ग्रुप है, आपको सबको पता ही है, जो कि लोगों की समस्याओं को, मांगों को सरकार तक पहुंचाने की कोशिश करता है और टैक्स प्रोफेशनल्स लोग हैं, उनको अवेयरनेस भी करवाने की कोशिश करता है। जैसे ये अभी इस बात का जो सेमिनार है जो रिफंड के रिलेटेड है और हाईकोर्ट, कर्नाटक हाईकोर्ट का जो जजमेंट है उसके संबंध में है, और हमारी एसोसिएशन यही आगे भी चाहेगी कि फर्दर इसमें जो भी सेमिनार, वेबिनार इत्यादि प्रेजेंटेशन जाए, वो आम आदमी की सहायता के लिए, टैक्स पेयर की सहायता के लिए, टैक्स प्रोफेशनल्स लोगों की सहायता के लिए जाएं, और जिससे सबको सहायता मिले, राहत मिले और सफलता भी हाथ लगे। थैंक यू मैम। मेरा इतनी तरफ से यही है, आप बताइए आगे फर्दर, और अविनाश सबको माइक हैंड ओवर करवाइए।
So basically AMTP has been representing on various issues as well. And VK Bothra ji and the team members are quite active. If you see the Twitter handle, they are always on the toes to ask amnesty, late fees, waivers and everything. I have been a privileged person to introduce Dr. Avinash Poddar sir, and this is my sheer gratitude to him that with one call he has accepted a request to be speaking on this specific topic. And I would like to talk about him as he's BCom, he's LLB, he's FCA, PhD, MCP, DSA from ICI, CFP, CM, then PGCCL, then he's IP from IBBI, he's also an ID from IICA, then he's FICA, then he's ICI certified valuer, he's also ICI IFRS certified, FAFD certified from ICI, ICI certified arbitrator, and ICI certified indirect taxes person. He is almost in practice from last 2 decades in direct as well as indirect taxes. And then he has been, advocate in including Supreme Court and various other high courts, including Delhi, Allahabad and other courts. Then he has been a past convener to various study groups, including South Gujarat by ICI. He is also empaneled as an arbitrator at Indian Council of Arbitration. He has been a vice chairman of GST Excise and Service Tax Committee of South Gujarat Chamber of Commerce and Industry. And he is a special invitee for GST and Insolvency and Bankruptcy Code Committee of ICI, GST and Indirect Taxes Committee of ICI. And he has been our mentor in the GST. So that goes without saying. I hand over the mic to Avinash sir. Avinash sir, all yours. Thank you so much.
Thanks a lot, Archana ma'am. At the outset, I would like to thank for considering me to be a person who can deliberate on the latest judgment of the Karnataka High Court. And so far as my acceptance is concerned, this is a family. I'm a part of this family. So I always consider this to be my honor, my privilege that my family members remembers me, considers me for this or for any particular deliberation. So far as the comments of Swapnil ji is concerned, sir, we all are learning. We all are in the process of learning, and throughout the life we'll be learning itself. So it's not a case. The only difference can be being a person who is practicing in High Court and Supreme Court, being a person who has already challenged this rule also in Honorable Gujarat High Court. I can have some better understanding, but I will not say better than you all, because reason being, you all are into the depth of this subject, and whosoever will be understanding the subject in depth, it is not necessary that he practices that or not, but understanding itself creates a lot of difference. So therefore, it's indeed an honor and privilege for me to be amongst all of you, to share the views on the judgment, recent judgment by the Honorable Karnataka High Court, again, which was argued by one of our own senior members, Mr. Raghuraman, who happens to be a very good mentor and guide for me. Now, before going into the technicalities of this particular case law, we must appreciate and understand the conceptualization with which the exports or imports were perceived in GST. Most importantly, we have always seen that no taxes can ever be exported. And therefore, we always have, like since years, since decades, we have seen that the tax cannot be exported. And therefore, always there is a privilege given, a benefit, a concession, a additional edge is given to the exporters. And the concept is, whenever a product is getting manufactured or traded but exported, tax cannot be exported. When I say tax cannot be exported, it is both ways. Input side tax also and output side tax also. Meaning thereby, whatever tax has been levied on the inputs, any input, may that be input goods or may that be input services, whatever taxes has been levied on the inputs, those taxes need not travel to the other country by way of an export. Meaning thereby it should not form part of the cost of the production and therefore exported. At the same time, when comes to the output, not the input, but the output. So there also we need to appreciate and understand that even in that case, the taxes are not leviable in exports and therefore no tax. So this is what is conceptualized at the inception. And this is not new in GST. It was there since decades, even in excise, VAT, all those eras. We have been observing, we have been understanding that there was not any chance of exporting a tax liability or a tax implication. Now, when I talk about import, so we need to appreciate that, yes, in import, there is leviability of tax. And therefore, whatever tax is being levied at the time of import, if it is services, then GST, if it is goods, then also IGST. But whatever tax is being levied at the time of import is available with the domestic purchaser, or rather the importer, as the input tax credit. But today, our endeavor, our discussion would be only qua exports and the perception and the law with regards to exports. Now, please understand and appreciate that with this backdrop that export cannot be levied any tax or a tax cannot be exported out of the country. With this backdrop, there is a provision under Section 16 of the IGST Act, which defines zero rated supply. Now, in this very judgment, which we are going to discuss today, we all must appreciate one thing, that the Honorable Court have discussed in detail about Section 16, Section 54, the CBIC clarifications that what is zero rated, whether zero rated and nil rated are one and the same, or there is any difference amongst that. That is something which has been categorically dealt with in this particular judgment. But the sum and substance of the judgment is that while exporting the goods or services or both, I'm repeating, while exporting the goods or services or both, taxes cannot be exported in any circumstance. And if any law, if any rule, if any subsequent development is happening, which is taking away this intention of the lawmaker, that the tax cannot be exported, that law will be treated as a bad law. Now, as Swapnilji has also introduced, he has also said that the rule is going to be, or rule is quashed or set aside, or rather I would say is declared as ultra vires by the Honorable Karnataka High Court. I presume that all the attendees, all the participants are well aware about the difference between striking down or declaring as ultra vires or reading down a law. I'll try to demonstrate that in nutshell in just 1 or 2 minutes, so that if anybody has any confusion, then that also can be clarified. When I say striking down or declaring as ultra vires can be ultra vires the act. It can be ultra vires the constitution. If it is a violation of Article 14, if it is a violation of Article 19, 1G, then it becomes ultra vires the constitution. If it is against or in violation of Section 54 or Section 16 of the IGST, then it is said to be ultra vires the act. In this case, it has been declared as ultra vires. A particular sentence has been declared as ultra vires the constitution, because it is violative of Article 18. Classes within classes is not allowed. And unless there is intelligible differentia, the class cannot be created. That is a settled principle laid down by the honorable courts in various judgments. So we'll be discussing that also in the given frame of time. And my endeavor today would be, I'll try to complete by 4:30 so that we can have discussion. If any queries, if any discussion has to be done, then that can be done for the rest of the time, so that we can make maximum use of it. It is not going to be a one-side monologue. I want it to be a dialogue, so that we all can discuss and deliberate and then make best of it. Because as I have said that I am a student of this subject, so I don't know very much or too much about this subject, but you all, when we all will discuss together, then certainly I'll be adding something to my knowledge, and we all will learn together. That is the purpose. So when I say ultra vires declaring, it means it is strike down. That cannot sustain, those lines cannot sustain. And when it is said that it cannot sustain or it is strike down, it means it is a strike down for everyone. For everyone, whomsoever it is applicable. In the entire country, it is applicable to each and every person. That is striking down of a law. But what about reading down of a law? That is also something which is very, very important. We all need to understand. When a law is said to be a correct law, I'm repeating, when a law is said to be a correct law, but in certain circumstances or in certain specific case, if that law is not applicable, then the court may read down that particular provision. Say, for example, a recent judgment of Honorable, I think of May 2022, a judgment was of Munjal Manish Bhatt. This was a judgment pertaining to whenever there is a sale of a property, then 1/3 deduction is given against the value of land. It was challenged because if the value of land is separately identifiable, then in that case, 1/3 should not be the embargo or the restriction. The actual value of land should be deducted. If it is 60%, 70%, then the actual value of land should be deducted, and on balance, the tax should be levied. So that was one case wherein the notification which said that 1/3 is to be deducted was declared to be ultra vires to some extent, but it was read down to a larger extent. Because if I am having a case wherein I am having a particular value of land which is separately identifiable, and then the value of construction, then our submission was that the tax should be levied only on construction because that is the supply of service. The land is anyways out of the purview of GST, and therefore only on services component the tax should be levied, and that presumption of 1/3 of the value of land should not be entertained in that case where we have value of land as a separately identifiable value. Court said yes, if Avinash is having the value of land separately and the value of construction separately, then levy tax only on construction. But if Avinash is not having, let us take an example, if Swapnilji is not having the classification, the bifurcation of value of land and value of service, then in that case, the notification will hold good. So this is reading down a particular provision, wherein this provision cannot be applied blindly to anyone and everyone. उस प्रोविजन को सबके ऊपर एप्लीकेबल नहीं कर सकते. आपको देखना पड़ेगा कि क्या वो व्यक्ति जिसके ऊपर आप उसको एप्लीकेबल करना चाहते हैं, उस व्यक्ति के पास जो नेसेसरी डिस्क्रिमिनेटिंग डॉक्यूमेंटेशंस है या नहीं. मेरे एग्जांपल में अगर मेरा वैल्यू ऑफ लैंड और वैल्यू ऑफ कंस्ट्रक्शन सेपरेट है अवेलेबल, तो केवल वैल्यू ऑफ कंस्ट्रक्शन को आप टैक्स करेंगे, टोटल एक्यूमुलेट करके टोटल करके 1/3 डिडक्शन देंगे, ऐसा नहीं होगा. So this is a difference between declaring as ultra vires and reading down the provision, which is very important. It is although very early, but I personally believe that we all are fighting, we all are struggling with 16(2)(c) provision. But that provision also to some extent is going to be read down by the courts. It will not be declared as ultra vires. Although the challenges are with regards to the vires of the provision, but it has to be read down. 16(4), it has to be read down. Over the period of time, maybe this is just why what I understand that it needs to be read down. It may not be declared as ultra vires, because ultra vires declaration will be a safeguard for everyone, even the defaulters, intentional defaulters. Whereas reading down will be applicable only for a particular person who is able to substantiate that no, he was not indulged into any such activity, and because of whom, because of this person, there is no loss to the industry or no loss to the revenue. So this is how we need to understand and perceive the difference between ultra vires and reading down. Now this law, this provision is declared as ultra vires by the Honorable Karnataka High Court. So I have given a backdrop of export, that the tax cannot be exported. We have tried to understand the provision of section 16 of the IGST Act, which defines zero rated supplies. Now, there is a difference, a clear-cut difference, which has been discussed in this particular judgment. Why I'm not taking you through this judgment totally is because we'll not be able to complete that in 3 hours also. So we need to understand the overview of this. So zero-rated supply, the terminology has been categorically discussed in this particular judgment, that zero-rated does not mean nil-rated. It does not include exempted. So we need to appreciate that zero rated includes 2 aspects. One, export of goods or services are both outside the country. Export of goods or services are both or supplies made to SEZ. And whenever I am entering into a zero rated supply, there is a provision of section 16 subsection 3 which gives 2 options. Now this is something which is very important. अब आप सर मेरे साथ थोड़ा सा आप मेरे साथ रहें और मेरे पर्सपेक्टिव को समझने की कोशिश करें, उसके साथ में हम कोर्ट के पर्सपेक्टिव को भी समझेंगे. तो 16(3) now it has been amended. 16(3) and 16(4). 16(3) is substituted, 16(4) has been inserted, but it is not yet made effective. So therefore, still we have to discuss 16(3) clause A and clause B. There are 2 options given. One, I can export without payment of tax under relativity. 2, I can export with payment of IGST. Both the options are given to me. Now, please understand and appreciate that when 2 options are given to a person, I can export with payment of IGST, I can export without payment of IGST under relativity. So the class of person is what? Class of person is one, which is exporter. I'm repeating, exporter. And therefore, this section 16 has to be read with section 54. What does section 54 says? Section 54 deals with refund. And section 54 subsection 3 subclause 1, it deals with a person who is exporting without payment of tax. That means under LUT. And for that person, as I've already stated, आप प्लीज पिछला ध्यान करें जो हमने डिस्कस करने की कोशिश की थी कि इंटेंशन ऑफ लॉ मेकर इज आपकी परचेजेस पे जो आपने टैक्सेस भरे वो भी आप एक्सपोर्ट नहीं कर सकते, मीनिंग देयर बाई गवर्नमेंट ने आपको अश्योरेंस दिया कि सर अगर आपने कोई परचेजेस की उनके ऊपर अगर कोई जीएसटी भरा तो वो जीएसटी हम आपको रिफंड देंगे, आप उसको अपनी कॉस्ट में ऐड करके एक्सपोर्ट नहीं कर सकते। आई होप वी ऑल आर गेटिंग द पॉइंट। इसी को प्रैक्टिकली इंप्लीमेंट करने के लिए सेक्शन 54 सबसेक्शन 3 क्लॉज 1 डाला गया, जिसने बोला कि आपकी एक्यूमुलेटेड क्रेडिट जो भी होगी वो आपको रिफंड दी जाएगी उस केस में अगर आप एक्सपोर्ट करते हो विदाउट पेमेंट ऑफ टैक्स, दैट इज अंडर एलयूटी और बॉन्ड। उसके लिए इन्होंने एक रूल बनाया विच इज रूल 89। और जो दूसरा केस था 16(3) में जो हमने डिस्कस किया कि विद पेमेंट ऑफ आईजीएसटी, तो जहां मैं विद पेमेंट ऑफ आईजीएसटी करता हूं वहां पे रूल बनाया गया रूल 96 कैपिटल ए, रूल 96 सॉरी। सो रूल 96 वाज डीलिंग विद the persons who are exporting with payment of tax, and therefore it was automatically linking and then getting the refund. There was no application to be made separately. But in rule 89, which was applicable for all those cases wherein the export is made without payment of tax, rule 89 was made applicable. और 89 के अंदर एक फॉर्मूला दिया गया सर, मैं एक बार स्क्रीन शेयर करके वो जजमेंट खोल लेता हूं so that we can run through that judgment also. And the purpose with which we all have accumulated today can be addressed. Just a second. What is this? Yes. My screen is visible. If anybody can confirm that.
Yes, sir.
Okay, thank you. So this is the judgment. We all are aware. Tonbo Imaging India Private Limited, the judgment by Honorable Karnataka High Court. Now see, what was the prayers? The prayers was twofold. One was to declare Rule 89, Sub-Rule 4, Clause C, capital C, to be declared as ultra vires, unconstitutional, but not the entire one. There was a part which was inserted by way of amendment on 23rd of March 2023, which was assumed to be, rather argued to be, an unconstitutional amendment. And second was Rule 93, which was again, but the petitioner in this petition have not pressed for Rule 93 to be declared as unconstitutional. Now, facts. Now, I am an exporter. I'm providing a unique supplies, which is not, or the similar goods are not available, and therefore it is a unique thing. So I'll not go into the rule now, just factual metrics. So I'm developing innovative designs in micro optics, lower power electronics, and so on and so forth. So I'll not be going into that. Important is, you can note it down. The important point is I'm into a unique selling or supplying of certain services, goods, whatsoever, but it is unique. I'm exporting that. Now I have exported for certain months. And those months are May 18 to March 19. May 18 to March 19, which is much prior to the amendment. Amendment is of 23rd March 2020. So therefore, these exports were made in May 18 to March 19. So therefore, this amended law should not be applicable. That is the first submission of the petitioner. कि सर जिस वक्त मैंने एक्सपोर्ट किया उस समय तो ये कानून ही नहीं था, और ये कानून आया प्रोस्पेक्टिव, रेट्रोस्पेक्टिव या रेट्रोएक्टिव ये कानून नहीं आया है सर, ये प्रोस्पेक्टिव आया है. दैट मीन्स इट इज एप्लीकेबल फ्रॉम मार्च 2020 ऑनवर्ड्स, or the date on which the notification provides. but certainly it is not applicable for the period May 18 to March 19. And therefore, the application of refund which was made by the petitioner for these months, that is May 18 to March 19, a show cause notice was issued and the submissions were made by the petitioner कि सर उस समय तो ये कानूनी नहीं था, उस समय तो नया जो आप टर्नओवर ऑफ जीरो रेटेड सप्लाई की जो डेफिनेशन की बात कर रहे हो और जो आप जीरो रेटेड टर्नओवर की बात कर रहे हो वो तो उस वक्त था ही नहीं, तो दैट शुड नॉट बी मेड एप्लीकेबल इन माय केस, बट द learned department officer has rejected the submissions and therefore he has dismissed it and rejected the refund. So the amount of refund, whatever applications were made for the purpose of claiming refund under Rule 89 was rejected on 30th June 2020. This can be seen from this paragraph. So now the question is, अब आपके दिमाग में दो क्वेश्चन आएंगे सर, और वो आने चाहिए कि सर अगर मेरा रिफंड का एप्लीकेशन रिजेक्ट हो गया तो क्या मैं डायरेक्ट हाई कोर्ट जा सकता हूं? द आंसर इज एब्सोल्यूट यस और नो, इन डिपेंडिंग ऑन दी, इट इज सब्जेक्टिव, इट डिपेंड्स ऑन दी सिचुएशन. अगर आपका रिफंड एप्लीकेशन रिजेक्ट कर दिया बिना आपको सुने, बिना आपको अपॉर्चुनिटी ऑफ बीइंग हर्ड दिए, दैट मींस इन वायलेशन ऑफ प्रिंसिपल्स ऑफ नेचुरल जस्टिस, देन यस यू कैन गो टू द रिट कोर्ट, बट इन नॉर्मल सर्कमस्टांस नो. Again it depends on the bench, again it depends on the judge. He may understand, he may allow you or allow your writ to be maintainable, or he may reject it. So in this case what has happened is there were two things. The orders were certainly being challenged कि साहब ये जो ऑर्डर इन्होंने नए लॉ में दे दिया है ये गलत है, क्योंकि मई 18 से मार्च 19 तो ये लॉ ही नहीं था. लेकिन उससे ज्यादा इंपॉर्टेंट है कि यहाँ पे वायरिस चैलेंज हुआ, और चूंकि वायरिस चैलेंज हुआ ये रिट मेंटेनेबल हो गई irrespective of the fact whether the order was issued or not. This is to be understood and appreciated by all of us. So therefore 89(4)(c) की वायरिस को भी, वैलिडिटी को भी इस लॉ में चैलेंज किया गया, and that is the purpose and that is the reason why the court has not directly said that writ is not maintainable. Now, what are the contentions of the petitioner? I'll not be dealing into that because all these contentions are dealt with in the order of the Honorable Court. But we will be dealing with the contentions of the respondents. अच्छा, एक चीज आप इसमें जरूर अप्रिशिएट करिए और इस ऑर्डर में समझने की कोशिश करें कि कोर्ट ने रेस्पोंडेंट के सबमिशंस को सिरे से खारिज किया है. Even while passing the final order, the court has observed in one of the paragraphs that respondent के जो submissions थे या objections थे, those were not so relevant that it can be discussed in detail in this order. I hope you all are getting this point, that the respondents were not in a position to comment anything. They have not reverted, they could not make up their point कि साहब ये लॉ सही है तो क्यों है, ये गलत है तो क्यों नहीं है. So these are the judgments on which the learned counsel for the petitioner have relied upon. Some of the judgments have been discussed in the order also, and we all are aware कुछ बहुत फेमस जजमेंट्स हैं, सायरा बानो, देन श्रेया बंसल, श्रेया सिंघल, then All India Federation of Tax Practitioners. These judgments are discussed in this also, but some and substances कि सर पहले आपको समझना पड़ेगा कि इंटेंशन क्या था लॉ का, और अगर आप उस इंटेंशन से डेविएट करते हो तो वो लॉ गलत हो जाएगा, आर्बिट्रेरी हो जाएगा. दूसरा कि अगर आप किसी क्लास में दूसरा क्लास क्रिएट करने की कोशिश करते हो तो वहां पे डिफरेंस जो है वो इंटेलिजिबल डिफरेंस होना चाहिए, कोई पर्टिकुलर पर्पस के लिए वो डिफरेंस क्रिएट होना चाहिए. नहीं कर सकते ऐसा नहीं, कर सकते हैं, लेकिन वो इंटेलिजिबल डिफरेंशिया वहां पे होना चाहिए, एंड दैट शुड मीट द पर्पस ऑफ द लॉ. If the broad purpose of the law is not met, then that law is bound to be declared as bad law or ultra vires. So that is what exactly has happened. Now, respondent counsel, only one paragraph. They have submitted their objections, and primarily their submissions were that the writ is not maintainable. Why they have said writ is not maintainable? Maybe on two counts, because this order does not depict that, but two counts. One, which is recorded here, that they have not submitted the proof of export turnover, which is mentioned in the instant claim, is 1.5 times of the value of like goods domestically supplied by the same or not. Why this is so, मैं रूल के लिए अभी लेके जाऊंगा तब आपको समझ में आएगा, बट प्रैक्टिकली दिस इज कि उनका ये कहना था कि भैया जो 1.5 गुना 1.5 टाइम्स डोमेस्टिक वैल्यू ऑफ सप्लाई ऑफ गुड्स की बात थी, वो आप जस्टिफाई नहीं कर सके, इसलिए हम उसको अलाउ नहीं करेंगे। दूसरा, जो मेंटेनेबिलिटी की बात वो कर रहे थे, मैं ऐसा मानता हूं कि उनका ये होगा कि चूंकि ऑर्डर ऑलरेडी पास हो गया है, since the order has already been passed, you have an alternate remedy of filing an appeal against that order, and therefore the writ should not be maintainable. So these might be the two submissions. Now let us see what the court has observed in this. First and foremost, before going into the discussion, the court has said that let us try to understand the GST perspective as a whole. The court records that 101st Constitution Amendment Act जब आया 16 सितंबर 2016 को, जब क्लियरेंस हुआ उसका, so the intention was to avoid the cascading effect of tax, that there should not be any cascading effect of tax. If there is any cascading effect, then that will certainly defeat the purpose of the GST law. आपको और मुझे सबको मालूम है कि ये कहाँ तक सही है या कहाँ तक ये चीज हुई, but not going into that. Then it says कि लेवी ऑफ कलेक्शन, जहां पे इंट्रा स्टेट की बात करते हैं, वहां के लिए CGST एक्ट बनाया गया और CGST रूल्स बनाए गए, और उसी के अंदर 89(4)C बनाया गया। देन फर्दर दे आर सेज इंटर स्टेट सप्लाई के लिए IGST बनाया गया, कर्नाटका के लिए KGST बनाया गया। सो इट्स अ मल्टी स्टेट टैक्स ऑन ईच सप्लाई इवेंट, द टैक्स विल बी लेवीड on the value addition. That is what is discussed by this honorable court. I think we should not go into all these things, because we all are aware कि जब मैन्युफैक्चरर बनाता है वो होलसेलर को देता है, होलसेलर उस पर कुछ वैल्यू ऐड करके रिटेलर को देता है, रिटेलर उस पर कुछ वैल्यू ऐड करके कस्टमर को देता है, एंड देयरफॉर इट बिकम्स द डेस्टिनेशन बेस्ड कंजम्पशन टैक्स, बिकॉज फाइनली द पर्सन हु इज going to bear this tax liability is the consumer, the final consumer, and therefore in the entire chain, the additional value or the value addition is the value on which the tax has to be paid. This is discussed in these paragraphs, and then it is said that destination based on consumption. Then further, All India Federation of Tax Practitioners, this also was underlying the principles of the value-added tax, that value-added tax is finally to be borne by the consumer. Need not go into all those things, but then one very important paragraph from VKC Footsteps has been taken. We all are aware about the VKC Footsteps judgment. Again, I would say that I'm also a proud person that I was a part of this judgment, although this judgment was against us, but whatever we were arguing in this judgment have been done by the government indirectly by amending the rule, wherein now even this service accumulation is getting or is being sought as a refund and given as a refund. So in VKC Footstep, the apex court, which has very importantly observed and noted, is to be taken into account. It says the idea which permeates GST legislation globally is to impose a multi-stage tax under which each point in a supply chain is potentially taxed. That is what we have discussed. Multi-stage tax, each point, each value addition must be taxed. Suppliers are entitled to avail credit of tax paid at an anterior stage. As a result, the GST fulfills the description of a tax which is based on value addition. So this is what we have discussed. This was an observation in VKC food step. And I'm going now to the last level. The tax which is paid at an interior stage of the supply chain is adjusted. The fundamental object is to achieve both neutrality and equivalence by the grant of seamless credit of the duties paid at an interior stage of the supply chain. So the purpose was that कोई भी पिछले स्टेज पे जो आपने टैक्स भरा उसको आप एडजस्ट करें एंड फ्यूचर में वो टैक्स को आप पे करें जो केवल वैल्यू एडिशन पे है, डिफरेंशियल टैक्स. सेक्शन 16 ऑफ द आईजीएसटी वी ऑल आर अवेयर. 54(3) sub clause 1, zero rated supplies made without payment of tax, and it says provided that no refund of unutilized input tax credit shall be allowed in cases other than. So exports without payment of tax is eligible, is qualified for being refunded back to you. Now 89(4), it deals with the formula which calculates the refund. If you can see the bold one, this is how the refund has to be calculated. Now this is very important to understand. Just give me 1 second. Now this formula says that what can be the maximum amount of refund? Turnover of zero rated supply of goods. Now please appreciate, now before discussing this एक चीज और डिस्कस करते हैं. सर सेक्शन 54 अगर आप देखेंगे तो 54 में ऐसा लिखा हुआ है कि आप रिफंड पीरियड के लिए क्लेम कर सकते हैं. Refund can be claimed for a particular period. That period can be monthly, it can be bi-monthly, it can be quarterly, it can be 6 monthly, it can be annual, whatsoever. So जिस period के लिए हम वो refund calculate कर रहे हैं, उस period का turnover zero rated supply of goods का plus turnover of zero rated supply of service. Just give me 1 minute. There is a call coming. Just I have to take this call. So turnover of zero rated supply of goods and turnover of zero rated supply of services, the accumulated turnover for that particular period for which you are claiming refund, multiplied by net ITC. Net ITC is the input tax credit, which is again defined in this particular proviso, in this particular provision, divided by adjusted total turnover. When I say adjusted total turnover, it is not only the export turnover, but also the turnover of domestic. Now, net ITC, input tax credit, which is availed on input and import services during the relevant period, other than the input tax credit availed for which refund is claimed under 4A and 4B or both. Now comes the dispute. Now, please read this with me. अभी तक हम लोगों ने पूरा डिस्कशन कर लिया, बट क्या चैलेंज है? Let us try to understand that. I was having a presumption because of which I have not discussed till now. Now we'll have to discuss and then deliberate how the court has taken a view in this. Sir, it says turnover of zero rated supply of goods means it does not include services. It says goods means the value of zero rated supply of goods made during the relevant period without payment of tax under bond or letter of undertaking. This is very clear. जो आपकी जीरो रेटेड सप्लाई की वैल्यू है वो वैल्यू जो आपने विदाउट पेमेंट ऑफ टैक्स एक्सपोर्ट किया है. Now comes the dispute. Or the value which is 1.5 times the value of like goods domestically supplied by the same or similarly placed supplier as declared by the supplier, whichever is less. Now they are saying, sir, अब आप समझने की कोशिश करें. Now they are saying कि for the purpose of calculation of refund, because आपने देखा refund में दो भाग हैं, turnover of zero rated supply of goods plus turnover of zero rated supply of services multiplied by net ITC divided by adjusted total turnover. So turnover of zero rated supply of goods के केस में वो क्या बोल रहा है या तो वो वैल्यू जो आपके एक्सपोर्ट की वैल्यू है विदाउट पेमेंट ऑफ टैक्स, या फिर 1.5 टाइम्स आपकी डोमेस्टिक सप्लाईज की वैल्यू। लाइक गुड्स को, सिमिलर गुड्स को अगर आप डोमेस्टिकली सप्लाई करें तो क्या रेट पे सप्लाई करते हैं, उसका 1.5 टाइम्स वैल्यू। तो वैल्यू ऑफ रियल एक्सपोर्ट्स और द वैल्यू of 1.5 times of the like goods in the domestic market, whichever is less, that has to be taken as the turnover of zero rated supply of goods. This will not include the turnover of supplies in respect of which the refund is claimed under subrule 4A and 4B. उसको एक्सक्लूड कर दिया है इस टर्नओवर में से। अब डिस्प्यूट क्यों अराइज हुआ? सर, क्या होगा उस सिचुएशन में जहां पे एक व्यक्ति डोमेस्टिकली सप्लाई ही नहीं करता, ही इज टोटली 100% एक्सपोर्टिंग, तो उसका डोमेस्टिक सप्लाई तो जीरो होगा, तो उसका 1.5 टाइम्स की वैल्यू भी जीरो होगी। सो दैट मीन्स ही इज नॉट एलिजिबल फॉर रिफंड। क्या होगा उस केस में? प्रैक्टिकली इसी केस में जो हम पढ़ रहे हैं, इस केस में ही इज इनटू द मैन्युफैक्चरिंग और डिजाइनिंग ऑफ अ यूनिक प्रोडक्ट। व्हाट विल हैपन इन दैट केस? जहां पे मैं कोई यूनिक प्रोडक्ट बना रहा हूं जो मार्केट में सिमिलर लाइक गुड्स हैं ही नहीं, हाउ डू गेट अ वैल्यू ऑफ दैट विच इज नॉट एप्लीकेबल? सर, स्वप्निल भाई जो सर्विसेज देते हैं दैट इज यूनिक, अर्चना मैम जो सर्विस देती है दैट इज यूनिक, अविनाश जो सर्विसेज देता है दैट इज यूनिक। नाउ हाउ डू आई कंपेयर a service being provided by Swapnil ji, Archana ji and Avinash to find out the value of supply by Virendra ji? So what is like kind of goods? It is not defined in the law. Sir, आप define तो करें कि like goods का मतलब क्या है? In absence of those definitions, how would we come to know that what is the meaning of like goods? That is the reason why it was challenged कि सर आप मुझे restrict नहीं कर सकते, अगर आप restrict करते हो तो now you are violating multiple things grossly. पहला, Article 14 clear violation. Reason being you are creating a class within class. Export का एक class है, 16(3) बोलता है कि दो तरीके से export किया जा सकता है, पहला with payment of IGST, दूसरा without payment of IGST. अब आपने ये restriction डाली without payment of IGST में, with payment of IGST में नहीं डाली। अच्छा चलिए 2 मिनट हम पीछे चलते हैं and let us try to understand what is the purpose of coming out with such kind of amendment. Sir, हमारे हिंदुस्तान में बहुत सारे हर तरीके के प्राणी हैं, हर तरीके के एक्सपोर्टर हैं। कुछ लोग 100 रुपए की चीज को 2000 बोल के एक्सपोर्ट कर देते हैं। सो ये उनको पकड़ने के लिए किया गया कि नहीं भाई, तुम 100 रुपए की चीज जो इंडिया में बेचते हो मैक्सिमम 150 रुपए तक एक्सपोर्ट करोगे तो हमारे को चलेगा, लेकिन तुम दिखाते हो 1000 रुपए 2000 रुपए एक्सपोर्ट और उसका ड्यूटी ड्रॉबैक ले लेते हो, उसका रिफंड ले लेते हो, दैट इज नॉट एक्सेप्टेबल। सर प्लीज अंडरस्टैंड, आप आधे परसेंट 1% जो ऐसे डिफॉल्टर्स हैं या इस तरीके के जो इंटेंशनली गलत करते हैं, उन लोगों के लिए आप लॉ नहीं बना सकते कि वो 100% के ऊपर एप्लीकेबल करते हैं, नंबर 1। नंबर 2, आपकी मल्टीपल स्टेजेस से पास होती है, आपका कस्टम्स भी उसको अप्रेज करता है, उसकी वैल्यूएशन करता है। उसने कैसे वो 2000 रुपए में पास कर दिया? अगर उसने पास कर दिया देन यू कैन नॉट चैलेंज, यू कैन नॉट से कि नहीं नहीं सर, कस्टम्स में तो 2000 रुपए की वैल्यू बराबर है, लेकिन जीएसटी में रिफंड लेने के लिए वो टर्नओवर में हम आपका केवल 1.5 गुना ही कैलकुलेट करेंगे, 1.5 टाइम्स। दिस इज नॉट डन, दैट इज नॉट द राइट वे ऑफ डूइंग इट। सो दे हैव क्रिएटेड अ क्लास विद इन क्लास व्हिच बिकम्स एन आर्बिट्ररी वायलेटिव ऑफ आर्टिकल 14। सेकंड कम्स कि सेक्शन 16(3)(b) क्या बोलता है और सेक्शन 16(3)(a) क्या बोलता है। आप विदाउट पेमेंट ऑफ टैक्स एक्सपोर्ट करिए तो आपका जितना एक्यूमुलेटेड क्रेडिट है वो सब रिफंड ले लीजिए, विद पेमेंट ऑफ करिए तो दोनों में फर्क क्या है सर? आज एक एग्जांपल लेते हैं सर, मेरे पास 1 लाख रुपए का क्रेडिट है, मैं एक्सपोर्ट करता हूं 1.5 लाख रुपए का, जिसपे 1.5 लाख रुपए का टैक्स है। पहले ऑप्शन में जहां विदाउट पेमेंट ऑफ टैक्स करूंगा वहां सरकार ने क्या बोला कि सर आप विदाउट पेमेंट ऑफ टैक्स एक्सपोर्ट कर दीजिए, क्योंकि टैक्स तो एक्सपोर्ट हो ही नहीं सकता, विदाउट पेमेंट आप कर दीजिए, और ये जो 1 लाख रुपए एक्यूमुलेट हो गया है इसका आप रिफंड ले लीजिए। दिस इज व्हाट द कोर्ट हैज सेड। दूसरे में ये बोला कि कोई बात नहीं सर, जो 1.5 लाख रुपए का आपका पेमेंट करना है आपको, उसमें से 1 लाख रुपए आप ये क्रेडिट यूज करके कर लीजिए, और बाकी का जो 50,000 है वो आप कैश में भर दीजिए. इन बोथ द सर्कमस्टांस द इक्वालिटी इज बीइंग मेंटेन्ड. Are you getting the point? It is equal treatment in both the cases, because in that also I'm getting refund of 1 lakh rupees. And in the second case where I'm paying through IGST and exporting, there also I'm getting the credit utilized of 1 lakh rupees for the purpose of discharging my tax liability. Therefore, अब आप ये कह देते हैं कि नहीं भाई, आप विद पेमेंट ऑफ टैक्स कर रहे हैं तो हम आपको दे देंगे, कोई दिक्कत नहीं है, आप 1,000-100 रुपए की चीज को 2,000 का दिखाइए, एक्सपोर्ट करिए, ऑटोमेटिकली रिफंड आ जाएगा. लेकिन आप विदाउट पेमेंट ऑफ टैक्स कर रहे हैं तो एक्सेप्टेबल नहीं होगा. तो क्लियर कट इनइक्वालिटी है. एंड देयरफॉर इन एब्सेंस ऑफ एनी इंटेलिजिबल डिफरेंशिया, दिस discrimination was declared to be violative of Article 14 of the Constitution of India. That is one. Second, let us see one by one what they have observed. Now, this is the observation of the court. One by one we'll going into that. But यहाँ क्या बोल रहा है ये पैराग्राफ 14 में? The court is saying कि भाई यहाँ पे कोई गेन नहीं होगा ये बोलने में that fundamental principle export करने का है to be competitive in the international market, and therefore the taxes are not added at the cost of exports. And this intention cannot be carried out by merely exempting the output goods or services for the following reasons. केवल आप आउटपुट को एग्जेम्प्ट करते हैं उससे ये पर्पस सर्व नहीं होगा, क्योंकि अगर आपने इनपुट पे टैक्स ले रखा है उसको आप रिफंड नहीं करते, so that means that you are increasing the cost of production, because मैं अपनी जेब से तो दूंगा नहीं वो टैक्स, जो मैंने इनपुट पे बेयर किया वो मैं अपनी कॉस्ट बना लूंगा, कॉस्ट बनाऊंगा तो एक्सपोर्ट मेरा कॉस्टली हो जाएगा. वही हमें रोकना है, and therefore the tax should not be exported. So this is what is dealt with in para 14. I will not be dealing into that. Then the court has taken cognizance of Annexure K, which was attached with the petition, which has discussed the zero-rated supplies, and it was issued by the Director General of Taxpayer Services (CBIC), जहाँ पे उन्होंने zero rating को explain किया कि what is exactly zero rating. Zero rating means a supply which is not nil rated, which is not exempt. So if I can read first line, please be with me. It says a supply is said to be exempt when it attracts nil rate of duty or is specifically exempted by a notification or kept out of the purview of tax. But if a good or service is exempted from the payment of tax, it cannot be said to be a zero rated. So zero rated and exempt or nil rated is totally different. जीरो रेटेड का मतलब यह है कि जिसकी सप्लाई के ऊपर कोई रेट का टैक्स नहीं हो सकता. आउटपुट एग्जाम नहीं है सर, टोटल सप्लाई एग्जेम्प्ट है, मीनिंग देयर बाय उसकी परचेजेस भी अगर कोई होंगी तो दैट आल्सो इज एग्जेम्प्टेड. सो देयरफॉर the reason is not hard to find. The input and input services which go into the making of good or provision of service has already suffered tax and not the final product exempted. Moreover, the output is exempted. Tax laws do not allow availment utilization of credit of the input services used for supply of exempted product. Therefore, in a true sense, the entire supply is not zero rated. So this is to be appreciated by all of us. और यही हम 9610 में भी आर्ग्यू करेंगे, यही हम किसी दूसरे प्रोविजंस में भी आर्ग्यू करेंगे कि सर एक्सपोर्ट में और एग्जेम्प्ट में ये सबसे बड़ा फर्क है. एग्जेम्प्ट में, एक्सपोर्ट में मुझे कहा गया है कि सर मैं 1 रुपए का टैक्स, जो मैंने अपनी इनपुट सर्विस चार्टर्ड अकाउंटेंट की सर्विस ली थी, उसने मेरे को इनवॉइस पे टैक्स लगाया, वो भी मैं बेयर नहीं करूंगा, वो भी मुझे आप रिफंड देंगे. दैट इज द पर्पस ऑफ जीरो रेटेड सप्लाई. नॉट गोइंग मच इनटू दिस. This is what CBIC declared. CBIC का जो भी clarification आया था वो यहाँ पे कोर्ट ने reproduce किया है, and therefore I am not going into that. यहाँ second paragraph अगर आप देखते हैं इस टेबल का, तो it says what is in case of exempt. पहला जो है exempt supplies, दूसरा zero rated. No tax on the outward exempted supplies. However, the input supply is used for making exempt supplies to be taxed. Now, what is the difference in zero rated? No tax on the outward supplies, input supplies also to be tax free. सो वो तो हम कर नहीं सकते, क्योंकि डोमेस्टिकली जब हम कुछ परचेज करते हैं तो उस पर तो टैक्स लेवी होना है, इट इज मैंडेट. दे कैनॉट exempt दैट टैक्स merely because I'm making an export, unless there is under some scheme or some duty drawback or something like that. But if there is no such scheme, then it will be a normal supply for my supplier, and therefore he will levy tax on that. And since he will levy tax on that, and the purpose of zero rated is कि भैया वो tax नहीं होना चाहिए, they will be giving me refund of this tax. That is the purpose of zero rate. Then it comes provisional refund, not going to that. 54(6) very recently Choksi export is one of the judgments of Gujarat High Court wherein I have argued this case, जहाँ पे वो रिस्की एक्सपोर्टर बना के मेरे काफी टाइम से टैक्स का रिफंड नहीं दे रहे थे. So I have challenged that into the Gujarat High Court, and Gujarat High Court has said कि नहीं, within 7 days of the filing of application 90% of the provisional refund must be given. So that is something not to be discussed now. तो ये राइट अप है पूरा उन्होंने जो CBIC का और उसका डिस्कशन किया है. सो आई विल नॉट बी इन्वेस्टिंग टाइम इनटू दैट. वेरी क्विकली विल गो टू दिस पार्ट कि जब ये डिस्कशन CBIC का अगर हम देखते हैं तो व्हाट इज द प्रिंसिपल विच इज इमर्जिंग आउट ऑफ दिस डिस्कशन. सो पहला है कि एंटायर सप्लाई चेन इन एन एक्सपोर्ट ट्रांजेक्शन शुड बी टैक्स फ्री. आई होप वी ऑल आर नाउ क्लियर कि ना कि मेरा एक्सपोर्ट या आउटपुट एग्जम्प्ट होता है कि उस पर टैक्स नहीं होता, बल्कि मेरे जितने इनपुट पे टैक्स दिए गए हैं, इनपुट सर्विसेज पे टैक्स दिए गए हैं, वो भी एक्सपोर्ट नहीं हो सकता. एंड देयरफॉर द एंटायर चेन हैज टू बी टैक्स फ्री. और अगर कोई भी लॉ ऐसा बनाया जाए जिससे वो टैक्स की चेन ब्रेक हो रही है और कोई पोर्शन टैक्सेबल हो जाता है या टैक्स रह जाता है उसमें, जो इस प्रोविजन में किया गया 4C में, then that provision is against the intention of the law and therefore violative of article 14(19)(1)(g) and also that particular section 16(3). Further it says there is no bar on availing utilization of input taxes paid for providing output supply in an export transaction. There is no bar, then you can utilize. So therefore IGST जब मैं पे करता हूं तो मैं इनपुट टैक्स क्रेडिट को यूटिलाइज कर लेता हूं, लेकिन जब मैं विदाउट पेमेंट ऑफ टैक्स एक्सपोर्ट करता हूं सो फिर वो मेरा एक्यूमुलेट हो जाता है, और अगर वो मेरा एक्यूमुलेट रह गया तो उस केस में फिर मुझे वो टैक्स को एक्सपोर्ट करना पड़ेगा, इसलिए वो रिफंड के प्रोविजंस हैं. फर्दर इट सेज जो इंटेंशन है 16(1)(a) का जीरो रेटेड सप्लाई का, वो एक्सपोर्ट ऑफ गुड्स और सर्विसेज दोनों पे लगता है. क्रेडिट ऑफ इनपुट टैक्स जो अवेल आप करते हो जीरो रेटेड सप्लाईज को बनाने के लिए, notwithstanding that such supply may be an exempt supply. So 16(2) says that credit of input tax may be availed for making zero rated supplies, notwithstanding that such supply may be an exempt supply. Even if it is an exempt, the credit should be taken. Now since GST would have been suffered at the input stage, ये सारे वही चीजें जो हम ऑलरेडी डिस्कस कर चुके, तो ये क्लियर बोलता है कि जो रजिस्टर्ड व्यक्ति है जो जीरो रेटेड सप्लाई बनाता है, he shall be entitled eligible to claim refund of such taxes paid in accordance with section 54. So उसको रिफंड लेना चाहिए, but subject to some conditions, safeguards and procedure as may prescribed. So it is quite obvious कि भैया ठीक है, आपको कंडीशंस तो लगाने ही पड़ेंगे एक्सपोर्ट के रिफंड देने के लिए. Now गुड्स का सप्लाई विद पेमेंट ऑफ टैक्स, विदाउट पेमेंट ऑफ टैक्स हो सकता है. दिस वी हैव ऑलरेडी डिस्कस्ड. 54(3) के अंदर वो रिफंड क्लेम होगा. सेक्शन 16 में कंटेम्पलेट किया गया है कि जो एक्सपोर्ट्स है वो जीरो रेटेड है, देयरफॉर इट इज टैक्स फ्री. देन रूल 89, इट इज प्रोवाइडिंग द मशीनरी फॉर कैलकुलेशंस ऑफ सेक्शन 54 refund, and the amount of refund is getting calculated by virtue of rule 89 of the law. Now ये amend होने से पहले it says the method of calculation before this amendment was that the formula was turnover of zero rated supply of goods and services both divided by adjusted total turnover multiplied by net ITC. तो difference क्या हुआ, अब उन्होंने turnover of goods separate कर दिया, zero rated turnover of zero rated services को separate कर दिया. पहले दोनों कॉमन करके एक साथ लिए जाते थे, अब इन्होंने ये सेपरेट कर दिया. और दो चीज में से जो लेस होगा वो वैल्यू आपको लेनी होगी एज अ टर्नओवर ऑफ सप्लाई ऑफ गुड्स, जीरो रेटेड सप्लाई ऑफ गुड्स। वो चैलेंज में है। पहला, वैल्यू ऑफ जीरो रेटेड सप्लाई जो एक्चुअल है। दूसरा, वैल्यू ऑफ 1.5 टाइम्स द वैल्यू ऑफ लाइक डोमेस्टिक गुड्स सप्लाइड बाय द सेम और सिमिलरली प्लेस्ड सप्लायर। अगर मैं डोमेस्टिक सप्लायर नहीं हूँ, केवल एक्सपोर्टर हूँ, तो मेरे जैसा कोई दूसरा सप्लायर, अरे मैं यूनिक प्रोडक्ट बनाता हूँ तो मेरे जैसा कोई सप्लायर होगा ही नहीं। तो व्हाट विल हैपन इन दैट केस? the rule, the amendment does not answer that and therefore arbitrary. So आर्टिकल 14 आर्बिट्रेरीनेस की बात करता है, इनइक्वालिटी की बात करता है, डिस्क्रिमिनेशन की बात करता है। उन सभी ग्राउंड्स पे ये लॉ जो है वो गलत है। 19(1) क्यों एप्लीकेबल है? क्योंकि आप मेरे बिजनेस को जो मेरा रिफंड मुझे मिलना चाहिए वो अगर कॉस्ट में एक्यूमुलेट हो जाएगा, सो दैट विल इम्पैक्ट माय वर्किंग कैपिटल एंड इनडायरेक्टली माय बिजनेस आल्सो। ये एक पैराग्राफ बनाया गया है, एक एग्जाम्पल है एनेक्सर एन में, जहां पे अगर आप देखेंगे तो 10 रुपए के मेरे 10 गुड्स थे, 100 रुपए का एक, 1000 रुपए की वैल्यू हुई एक्सपोर्ट की। सेम डोमेस्टिकल मार्केट में 300 रुपए का बिकता था, यानी इसकी वैल्यू हुई 30%, तो मल्टीप्लाइड बाय 1.5, दैट मीन्स 450। तो 450 विल बी टेकन एज द वैल्यू ऑफ टर्नओवर, वेयर एज एक्चुअल वैल्यू इज 1000 रुपीज। दूसरे एग्जाम्पल में मेरा डोमेस्टिक सप्लाई 0 था, तो माई value as per 89(4) will become 0, which is absolutely bad. It cannot be accepted in any case. Now, this is the para 17 is the important paragraph, because here the court opines and gives the decision. Court says, in my considered opinion, the impugned amendment to Rule 89, Sub-Rule 4, Clause C of the CGST rules is illegal, arbitrary, unreasonable, irrational, unfair, unjust, and ultra vires Section 16 of the IGST Act and 54 of the CGST Act for the following reasons. So it is not only violative of Article 14 and 19, but it is also violative of or ultra vires Section 16 read with Section 54. पहला क्या बता रहे हैं वो, क्यों ये बोल रहे हैं कि जीरो रेटिंग का मतलब सेक्शन 16 के हिसाब से कि एंटायर जो चेन है वो टैक्स फ्री हो, जबकि इस केस में ऐसा नहीं हो रहा है। एंड देयरफॉर दिस रूल, लास्ट 3 लाइंस में पढ़ रहा हूं, दिस रूल इन whittling down such refund is ultra vires in view of the well settled principle of law that rules cannot override the parent legislature. And therefore ये बहुत क्लियर सेटल्ड प्रिंसिपल ऑफ लॉ है कि जो सबऑर्डिनेट लेजिस्लेचर है, जो रूल है, इट कैनॉट ओवरराइड the parent provision which is the statute, and statute clearly provides कि आपको पूरा पैसा जो एक्यूमुलेट हुआ है वो रिफंड मिलेगा। सो आप उसको रिस्ट्रिक्ट अगर कर रहे हो, सो दैट इज नॉट इन अकॉर्डेंस विद द पेरेंट प्रोविजन एंड देयरफॉर इट इज बैड इन लॉ। नेक्स्ट रीजन भी उन्होंने दिया कि 14 और आर्टिकल को भी देखें अगर आप कॉन्स्टिट्यूशन में, तो जो क्वांटम है रिफंड का, अनयूटिलाइज इनपुट टैक्स क्रेडिट का, it is getting restricted only in cases of 16(3)(a, not in 16(3)(b), जो हमने पहले भी डिस्कस किया कि अगर मैं विदाउट पेमेंट ऑफ आईजीएसटी कर रहा हूँ 16(3)(a में, तो ये रूल मुझे एप्लीकेबल कर रहा है और मुझे रिस्ट्रिक्ट कर रहा है। लेकिन अगर मैं विद पेमेंट ऑफ आईजीएसटी कर रहा हूँ तो ऐसा कोई रिस्ट्रिक्शन नहीं है। देयरफॉर देयर इज नो इंटेलिजिबल डिफरेंशिया बीइंग क्रिएटेड एंड henceforth it is bad in law. It is violative of Article 14 and 19(1)(g). So next is कि आर्टिकल 14 क्या बोलता है। आर्टिकल 14 does not restrict the reasonable classification for the purpose of legislation, but there are 2 tests which are involved and those needs to be passed. पहला टेस्ट है इंटेलिजिबल डिफरेंशिया का, which distinguishes person or things that are grouped together from others left out in the group. अगर इंटेलिजिबल डिफरेंशिया है, it is a valid law. If there is the absence of intelligible differentia, then it is not a valid law. It is a violative of Article 14 because it says equal treatment, equal applicability of a particular law, equal applicability of a particular privilege or a benefit. And if you are restricting that and unable to provide any intelligible reason because of which it is being restricted, then it becomes violative of Article 14. एंड दूसरा, पहला है इंटेलिजिबल डिफरेंशिया, एंड दूसरा कि जो डिफरेंशिया है इट मस्ट हैव अ रैशनल रिलेशन with the object sought to be achieved by the statute. Now please appreciate friends, as we have already discussed, अभी तक जो हम आधा पौना घंटे से डिस्कस कर रहे हैं, nothing beyond to be discussed in this. The only concept is export is zero rated. The taxes cannot be exported. And therefore, creating a difference and making that amount which was supposed to be refunded in the ordinary circumstance restricted to some level is not in consonance, is not in relationship, or is not in direct connection, not in accordance with the object of the law. And the object of the law was that the exports has to be zero rated. So therefore 89(4)(c दोनों ही parameters पे fail हो जाता है, because वो 16(3)(a और 16(3)(b) में distinguish कर देता है without any proper clarification, प्रॉपर रीजनिंग. एंड दूसरा कि जो लॉ का पर्पज है सेक्शन 16 का कि भाई सबको रिफंड मिलना चाहिए, वो पर्पज भी मीट नहीं होता. दैट पर्पज इज आल्सो गेटिंग वायलेटेड, एंड देयरफॉर इट इज एब्सोल्यूट इन वायलेशन ऑफ आर्टिकल 14. So it clearly says 89(4)(c) is arbitrary and unreasonable as much as there no rational nexus with the objectives sought to be achieved by section 16 of the IGST, because it is not applicable. Now moving to next जो रीजन जिसकी वजह से उन्होंने डिक्लेयर किया, वो सिंपल कह रहे हैं कि एक्सपोर्ट्स में द अवेलेबिलिटी ऑफ द रोटेशन ऑफ फंड्स इज एसेंशियल फॉर अ बिजनेस टू थ्राइव. द एंटायर कंसेप्ट ऑफ रिफंड ऑफ अनयूटिलाइज्ड इनपुट टैक्स क्रेडिट रिलेटिंग टू जीरो रेटेड वुड बी obliterated, means it will be defeated in case the respondents are permitted to put any limitation and condition that takes away the petitioner's right to claim refund of all taxes paid on the domestic purchases used for the purpose of zero rated supply. The incentive given to exporters would lose its meaning, and this would cause grave hardship to the exporters who are earning valuable foreign exchange for the country. It follows that from that exporters would have factored in such incentives in the pricing mechanism when they quote, and consequently the restriction of the same by the impugned amended 89(4)(c) would be highly unreasonable. बहुत क्लियरली लेट डाउन कर दिया है कि भाई जब मैं अपनी कोटेशंस देता हूँ, जब मैं अपनी फॉरेन सप्लाईज करता हूँ, तो मैं ये फैक्टर कर लेता हूँ कि सर ये तो जो मेरा टैक्स लगा हुआ है ये तो मुझे रिफंड मिलने वाला है, और फिर फर्दर आप कोई लॉ लाते हो जिसकी वजह से वो रिफंड को मेरे कम कर देते हो. सो इनडायरेक्टली दैट विल बी अ कॉस्ट टू मी, एंड सिंस इट विल बी अ कॉस्ट टू मी, माय रिफंड विल गेट रिड्यूस्ड, एंड सिंस माय रिफंड विल गेट रिड्यूस्ड, इट विल कॉज हार्डशिप टू मी और अ फाइनेंशियल लॉस टू मी. सो देयरफॉर इट इज अनरीजनेबल. सो आर्बिट्ररी, irrational, unreasonable, unfair, and also violative of articles 14 and 19(1)(g) of the Constitution of India. Next क्या बोला? It is also vague. It is also suffering from the vice of vagueness. क्यों? क्योंकि लिखा है like goods, similarly placed supplier, but उसको open ended रख दिया है. They have not defined what is like goods, what is similarly placed supplier, and therefore it is not possible to have any like goods and same or similarly placed supplier for the unique and customized product. इस particular case में इनका ये एक unique product बनाते हैं, तो उस केस में तो similarly placed supplier कहाँ से लाएंगे या like goods कहाँ से लाएंगे? So therefore it is vague to that level, to that extent. Next बोल रहा है कि ये amendment जो आपने किया, it is also not capable of answering कि what will happen in a situation wherein no supplies are made domestically. अगर मैं इंडिया में कोई सप्लाई ही नहीं कर रहा हूं, उस सिचुएशन में क्या होगा, वहां पे कैसे मैं इसकी वैल्यूएशन करूंगा, ये रूल कैसे एप्लीकेबल रहेगा, एंड देयरफॉर उस हिसाब से भी दिस इज नॉट द करेक्ट लॉ. क्लॉज जी में बोल रहा है कि ये जो लॉ है, जो अमेंडमेंट है, it is finally restricting the amount of refund which actually should not be. जो हमने annexure N में देखा कि 300 रुपए में इंडिया में बेचते हैं, डोमेस्टिकली बेचते हैं तो उसका 1.5% 1.5 टाइम्स यानी 450 रुपए, और जबकि एक्चुअल वैल्यू है 1000 रुपए। सो वो ये बोल रहा है कि कोई डिफाइनिंग रीजन नहीं है कि वो ऐसा क्यों कर रहे हैं, वाई 1.5, एंड देयरफॉर टू दैट लेवल इट इज आर्बिट्ररी. So that should not be permitted and therefore it is arbitrary. Further it is saying clause H में that जो purpose है zero rated का, जो rating का जो object है, that tax free, it will be lost if I am made or the exporter is made to suffer GST. Would either it will pass on to the foreign supplier, either that tax will become cost and it will be passed on to the foreign supplier, or he will have to absorb on himself. So पहले ये बोलेगा कि टैक्सेस एक्सपोर्ट हो रहे हैं, विच इज अगेन अगेंस्ट द पर्पस, एंड सेकेंड कि अगर ऐसा नहीं है तो वो अनकॉम्पिटिटिव बना देगा. जो पॉलिसी ऑफ द गवर्नमेंट है जो चाहती है कि एक्सपोर्ट आप बढ़ाएं, उसके वायलेटिव होगा. तो दिस अगेन इज नॉट हैविंग द गुड इम्पैक्ट बिकॉज ऑफ दिस अमेंडमेंट. एंड फर्दर इट सेज क्लॉज आई में दैट अमेंडमेंट इज ऑल्सो अनरीजनेबल एंड आर्बिट्ररी because the adequate reasoning is not present. Why you are amending this? Why 1.5 times? There is no reason given. There is no definition of similar place supplier. There is no definition of like goods, and therefore it is also arbitrary and unreasonable. Because ये lines अगर आप देखते हैं तो as amended, it aims to just the opposite by restricting the quantum of refund of tax available in making such exports, and therefore what is seen is that including domestic turnover in definition of zero rated supply, which is meant to cover only export, is clearly arbitrary and unreasonable, as that would defeat the provision of law to grant refund on zero rated supplies. Therefore, I am also of the view that terminology used in the impugned rule, that is like goods and same or similarly placed supplier, does not have any precise meaning in the said rules, and no guideline is present in that respect. Then para 19, the Honorable Justice is relying on Saira Bano case, which has very beautifully discussed about the Article 14, and they have clearly said that unless there is any rational, if there is no rational, then the arbitrariness is there. And if I have to read this, subordinate legislation can be challenged on any grounds available for challenge against plenary legislation. This being the case, there is no rational distinction between two types of legislation when it comes to this ground of challenge under Article 14. The test of manifest arbitrariness, therefore, as let down in the aforesaid judgments, would apply to invalidate the legislation as well as subordinate legislation under Article 14. Manifest arbitrariness, therefore, must be something done by legislative capriciously, irrationally, and or without adequate determining principle. Also, when something is done which is excessive and disproportionate, such legislation would be manifestly arbitrary. We are therefore of the view that arbitrariness in the sense of manifest arbitrariness, as pointed out by us, would apply to negate legislation as well as Article 14. Then it has already also relied upon the Shreya Singh's case, wherein the apex court has held about the vague laws, that how the law can be declared to be vague because of the absence of intelligible differentia and all. So not going into that. And then further, para 21. Para 21 says, as rightly contended by the petitioner, जो एक्सपोर्ट्स होते हैं उसमें अवेलेबिलिटी ऑफ रोटेशन ऑफ फंड इज एसेंशियल फॉर बिजनेस टू थ्राइव. और एंटायर कंसेप्ट जो है अनयूटिलाइज इनपुट टैक्स क्रेडिट के रिफंड का, दैट इज बेस्ड ऑन दैट. वो एंटायर कंसेप्ट फेल हो जाएगा अगर हम ये लॉ को करेक्ट लॉ मानते हैं. एंड देयरफॉर जो इंसेंटिव्स गवर्नमेंट देना चाहती है गवर्नमेंट एक्सपोर्टर्स को कि वो टैक्स को एक्सपोर्ट ना करें और उनकी कॉस्ट को नीचे रखें, इसलिए हम उनको रिफंड दे देंगे, दैट एंटायर पर्पस विल बी डिफीटेड. So taxes in no circumstance can be exported. Then further it says कि जो revenue है, respondents हैं, उन्होंने एक contention किया that जो amendment था 39 GST Council meeting में हुआ, which has discloses that the above only ground of amendment seems to be possible misuse without factual data supporting the same. Reasons for such amendments based on possible misuse without adequate defining data cannot be countenanced as having a reasonable basis in law. Issue of misuse cannot be generalized. Every such misuse is required to be ascertained and verified before asserting that there has been a misuse. Therefore, खाली कह दें कि कोई misuse कर लेगा, that is not sufficient. It has to be proven. And therefore, it is also well settled that if the government perceives that there could be possibly a misuse of a provision, it should adopt measures to keep a check on the same. However, the law cannot be amended on the premise of distrust. This is a wonderful observation of this Honorable Court in para 22. I think this can be quoted a lot of times in the arguments of pertaining to GST cases. Then Sant Steel case is being relied upon merely on the basis कि भैया आप ऐसा law नहीं बना सकते जिसका impact कुछ limited लोगों को हो. You should make a law which should be in accordance with the entire purpose of the lawmaker. Then para 25 becomes relevant. It is also relevant to note that the aforesaid GST Council meeting, it was stated that FOB value of exports will not be changed, which would mean that there is no doubt about the valuation of goods. We all are aware, as I've already stated, we have already discussed कि भाई ऐसा नहीं है, इसकी appraising भी होती है. Appraise होके जाता है तो वो value of goods तो आप change नहीं कर सकते. तो आप एक artificial 1.5 times लिख देते हो, arbitrary process बना देते हो without any reasonable explanation, without any application of mind, is something which is irrational, and therefore the policy of the government itself will have to satisfy the test of rationality and must be free from arbitrariness and discrimination. In Pepsi Foods में भी ये clearly लिखा है कि unequals have been treated equally. So whenever equals are getting treated unequally or unequals are treated equally, in both the cases it is violation of Article 14. And यहाँ पे clearly है, expression permissible policy to the action would refer to a policy so and so. If the policy itself is arbitrary and discriminatory, such policy will have to be struck down as found in para 20 above. So therefore, on this basis, the final decision of the court was that the impugned rule is arbitrary and unreasonable in as much as the possibility of taking undue benefit by inflating the value of zero-rated supply of goods cannot be a ground to amend the rule, which deserves to be declared invalid on that ground, on this ground also. Insofar as the other contentions urged by the respondents, revenue, in their statement of objection and before this court, the same are neither relevant nor germane for the adjudication of this petition, and consequently, the same has not been referred to in detail in this order. The court has not found, court को ये भी नहीं लगा कि भाई respondents जो argue किया उसको हम detail में record कर लें, because the court found that to be irrelevant. So therefore, for these reasons, the court was of the considered opinion that so and so amendment by notification so and so deserved to be declared as ultra vires and invalid, and consequently it deserved to be quashed. So also the impugned order of 30th June 2020, which is based on the impugned amended, also deserves to be quashed, and consequently respondent are to be directed to accept the refund applications of the petitioner and grant refund in favor of the petitioner together with applicable interest within a stipulated time frame. And finally, the court has in para 2, like para 30 and sub para 2, clearly said the impugned offending words or the value which is 1.5 times the value of like goods domestically supplied by the same or similarly placed supplier, which is appearing in 89(4)(c), as amended by these notification, as also violative of Article 18, 14 and 19 of the Constitution of India, and resultantly the same is quashed. So therefore, this is the basis on which the Honorable Court has quashed the rule, this part of the rule, and have declared is ultra vires. But अब अगर हम conclude करते हैं तो it is so simple to say that the purpose of export is making the export zero rated. And the purpose of zero rating is that neither the inputs nor the output should be taxed. If it is taxed, then that money should be refunded back, or that tax amount should be refunded back. If there is any restriction placed by any law for those refund, then that restriction seems to be in contrary to the intention of the parent provision, which says zero rated supply. And therefore, those restrictions must be declared to be ultra vires. This is how this law is perceived. Now, this was all from my side. I hope I can make out some points clear to all the participants. And if any queries are there, I'll be more than happy to answer them. Over to you, Swapnil ji, Archana ji.
Yes, Swapnil ji, we can take the question answers, right?
Yes.
So, if you pardon, I know I'm not the right person to ask it, being a management person. But sir, एक बताइए अभी जो हमने discuss किया case में, the court has very specifically mentioned that the entire supply chain is not supposed to be taxed when it is in the course of the exports. Now, if you see my entire purchases is taxed. In the earlier previous laws, we used to give certain forms, and the purchaser, the vendor used to not tax us based on those forms, and the chain used to be free, tax free. Here, what is happening is we are paying the taxes, the entire capital is getting blocked, and then again, if you export with GST, you get the funds. But if you export with LUT, it takes more than 6 months sometimes to process the refunds. Is it not indirectly taxing the entire chain of exports?
I will not say it is taxing the chain of export, but yes, they are delaying the process. They are retaining my money to some extent, which directly or indirectly is impacting my pocket, because the interest certainly is going to be leviable on that because of the delay in processing of the refund. But when I see, or when we see the provision of the law is very clear, because it also deals with 54(6), which says provisional refund. And in case of zero rated supplies, it is not only zero rated supply with payment of tax, but it is applicable for all zero rated supply of goods or services. The 90% has to be provisionally refunded within 7 days of making of the application, which unfortunately is not being done by the departmental officers. And therefore, that is something which needs to be, or which we as an association should raise a voice. Because जब law बोलता है कि आपको 7 दिन में refund दे देना है, then on what basis you are retaining those refund amounts? That is something which we can take care of. But otherwise, the purpose of law was never to retain our money for 6 months. But आपको भी पता है, मुझे भी पता है कि वो क्यों ऐसा किया जा रहा है, वो क्यों ऐसा कर रहे हैं. Unless they are obliged, unless they get their benefit, they are not passing the refunds. Unfortunately, this is happening. और IGST refund में इसलिए हो जाता है because वो system dependent है. System में match होता है. As soon as it is getting matched, the refund is being processed. But now they are playing games of risky exporters and all those things. So these are the practical difficulties, not from the legality point of view, but yes, from practical point of view, it is a very, very, very important question. And they should, and therefore, जब discussion हो रहा था, तो I have mentioned this also. कि earlier times में there were the policies, the procedures, which if adopted, तो आपकी tax input पे लगता ही नहीं था. The same should be there. They should come out with such policies even in GST. If I'm finally going to export, then in that case, my input should not be taxed. But let us see when they come out with some such kind of procedures.
Yeah, thank you, sir. Any Swapnil, you have query? सर आपका रिस्की एक्सपोर्टर्स वाला जो केस था, जो आपका गुजरात कोर्ट में चल रहा है, is that reached to conclusion? Because still the cases, we are receiving the cases of risky exporters.
No. In that case, the order has been passed and the person has got the refund also. And there is another case in Bombay High Court also, wherein the government has committed that we'll be paying refund. So वो केस भी लगा हुआ स्पेस टेक करके है. Now it is listed on 13th of April. The government has commented that they will be passed because अभी उन्होंने क्या किया 89 rule 96(4) में they've inserted a subclause C which is retrospective from 1st July 2017. वो बोल रहे हैं कि जहाँ पे भी इस तरीके की कोई क्वेरीज आती हैं वहाँ पे वो भले ही आपने IGST पे करके किया है लेकिन they will automatically upload RFD 01 for this supplier for this person. Then it will be verified in the normal course जैसे normal refund की verifications होती है and then the refund will be passed. So they have adopted this measure also in many of the cases. So in my case, which is pending before the Bombay High Court, they said that we have adopted this process of 96(4)(c) and therefore we have uploaded RFD 01 automatically from our side. It is under process and once it is processed, you will get the refund. तो जितने भी risky exporter के केस हैं वो इस तरीके से अभी डील हो रहे हैं. वो 96(4)(c) में आपको ऑटोमेटिकली अपलोड कर देते हैं आपकी रिफंड एप्लीकेशन, उसको प्रोसेस करके वो पास कर देता है लोकल आपका GST ऑफिसर in spite of the customs officer as in case of the IGST paid exports. This is what they have done. But yes, in few of my cases, I got the refunds.
Yeah, so then what I understand is that refund application is made by the department on behalf of the
Correct.
at the back end.
Correct, absolutely.
Is it not opening a door as in, you know, the department that the fee will
I think I'm not able to hear. I am not able to. Your voice is cracking. Either there is
comfortable, like, sir, as sir, I was saying, as in department अगर dealer के behalf पे RFD 01 upload कर रहे हैं from the back end, is it not opening a new big Pandora in Information Technology Act, wherein they are stepping into the foot of the dealer and uploading the data on their behalf and, you know, telling the world that, you know, they can, you know, act on behalf of a dealer without the knowledge of the dealer? Because RFD 01 form says I'm submitting this detail based on my best of understanding and the refund that I'm claiming is, you know, true and correct, right? Now if department is uploading this, it's somewhere not creating a gap, as in backend technology में क्या हो रहा है फिर क्या पता.
मैम 100% I agree with you, but unfortunately होता क्या है कि जिनका प्रोसेस हो रहा है they are not objecting, and unless they object it cannot be challenged. Because I have raised this query to many कि साहब आपका अगर आपके एब्सेंस में कोई अपलोड कर रहा है and whether it is being uploaded correctly or not, that is they are verifying. So in spite of that, why it should not be given to you in dashboard and then you can upload it? But unfortunately ऐसा नहीं है. Nobody has come forward to challenge it. This is the present situation. But yes, I do agree with you that my application cannot be filed by the department on their own.
Yeah, Avinash sir.
Query solution. Swami ji, are you there? Ajay ji has.
Hello.
Yes, please.
Yes.
Yeah, good evening, sir.
Very good evening.
Sir, question is regarding that processing of refund. There are two parts actually. So one, that after we file the GST refunds in usual manner, now there are instructions for this Gurgaon's case. I have come across a discussion with the department that they have internal instruction not to process the refund in, can say, sooner or fastest manner. Now they're taking time of 60 to 90 days in processing the application, even after RFD 8. So while the law says otherwise, can this situation be challenged in the court? Because internal instructions, whatever it is, cannot bind any taxpayer, that he has to, say, block his working capital for 2 months, 3 months, and then again he has to give something.
See, certainly something which is not in accordance with law can be challenged. That is not at all a question. But issue is law says कि आपको 60 days में दे देना चाहिए. अगर आप नहीं देते हैं, then section 56 comes into play, and then they say that it has to be refunded along with interest. So the departmental officer will say, even if there is internal, we ignore the internal circular or whatsoever, then also it is our duty and our endeavor to verify. And it is taking time to verify your supplies, your inputs, on the basis of which the refund is being claimed. And therefore, we are finally paying you interest. So I don't think that this is challengeable to that extent. But yes, if some internal circular is there, which is absolutely against the law, then it can be challenged. What I mean to say is the transaction or the delay qua your case may not be challenged, but that internal circular on the basis of which they are delaying the processing can certainly be challenged.
Right. But apparently the department, usually what I have seen, they never pay interest on delayed refunds. That for that.
I have not come across any such case wherein wherever there is a delay, compulsorily they are paying interest.
Okay.
So we'll have to ask for interest. If they deny, then we can go to the court, because interest is our right. If we delay in making payments and then they are charging interest and they are saying that this is against the compensation for the loss they have suffered, then in our case also, if they are delaying it, then they are blocking the working capital, and therefore they are supposed to compensate us. They will have to pay the interest because that is the statutory provision, and not only 6%, but I have come across a lot of such cases wherein 9% has been granted by the courts. So then you can challenge. If the interest is not being paid and the delay is there within 60 days, the refund is not being processed, then certainly you can challenge and ask for the interest.
Right, sir. Right. Thank you.
Yes, do we have any other queries, please?
Swapnil ji, I think we can conclude.
Okay. Sir, it was a very nice session. Understanding your analysis of the judgment as well as the surrounding facts, the GST law, and the history of GST and of exports and everything. And I would like to thank you on behalf of everybody and Team AI and DPA for affording us the opportunity. Thank you very much.
Thank you. Thank you so much.
Thank you, sir.
Thank you, ma'am.
We'll conclude.
Thank
Thank
you.
you so much. We'll
Thanks a lot.
conclude now. Yeah. Thank you. VK sir, you can end the session, sir.
थैंक यू एवरीवन। अविनाश सर ने बहुत ही अच्छा रिफंड के बारे में बताया, प्रोज और कॉन्स, और जो अपने एक्शन फ्यूचर में ले भी सकते हैं। इवन अगर आपके लिए वो रिफंड में डिले कर रहे हैं तो भी, अगर डिले जेन्युइन है या फिर कोई सर्कुलर के रिगार्डिंग है, तो भी बहुत अच्छा बताया उन्होंने। धन्यवाद सर का। सर ने एक ही निवेदन में और स्वीकार किया और सबको स्पीकर के तौर पे आने के लिए एक्सेप्टेंस दी। थैंक यू अंजना मैम, थैंक यू स्वप्निल सर, थैंक यू ऑडियंस, थैंक यू सो मच।